Welcome back to the PI Show, viewers. Before the break, we we're talking about this case of Finch, Harry, and John, the sex change.
Yeah,
Alan,
Helen, and Alan.
Alan.
Yeah, but John, it went to the High Court. It was a total and permanent disability dispute. I think the quantum's probably over $200,000.
Yeah, could be even more.
Even more.
Mm.
And initially the trustees for Telstra denied the claim, and then he had to go to court, and ultimately the court had to decide on what basis the trustees denied the claim. So
the initial denial was on the basis that he had not been out of work for more than 6 months.
He fell short by 6 days.
Yeah, after he left Telstra.
Mm.
Yeah. So the trustees took a very dim view of the case, I think.
Yes.
But the judge in the first instance looked after him, Harry. Judge Byrne in the Supreme Court gave him his entitlements, and then it went to the Court of Appeal.
Yeah, and the Court
he missed out.
The Court of Appeal reversed the decision.
Gave a very restrictive interpretation of the trustee.
Yeah.
They said that you've got to clock up the 6 consecutive months with that employer.
After you cease work.
After ceasing work.
Yeah. And then the High Court then had a careful look at the totality of things. 5 judges in the High Court.
5 judges.
Decided that you didn't have to be continuously employed by one employer. They pointed out all the anomalies and the unfairness of it all.
Well, it was good because what they've done effectively is said to the trustees, you've got to make inquiries, a proper inquiry. You just can't rely on...
First of all, they said that you didn't need the 6 months with that employer.
No.
And secondly, they said, look, if someone applies, you've got to take it very seriously and investigate.
That's correct.
Investigate the actual injury involved. They threw up the scenario where, what about if there was a traumatic incident and the disability commenced straight away? Well, if he or she hasn't been working, ceased
away
work
for 6
for more
months.
than 6 months,
They wouldn't qualify.
They wouldn't qualify, and that's not the purpose of the disability benefit.
No. And look, I think the High Court, again, emphasised, and I think that's an excellent part of the decision, they emphasised how important superannuation is to the people in Australia. And part of superannuation is usually an insurance policy to say if you're disabled, you're entitled to a lump sum benefit.
It'll give you some sort of financial security at least.
And
yeah.
they said, Tony, that next to your home, superannuation is probably the most important asset that you have.
That's exactly right, for most people.
For most people.
Yeah.
So it seems there's been some public policy considerations in this judgment also.
Yeah, they emphasised, and to me they emphasised how important it is for the trustees to thoroughly investigate the entitlements of people. They can't rely on one report or two.
It seems a shift on the original decision in Carger and Paul, Harry, where they said that you couldn't really touch at the trustee's discretion.
Yeah.
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 So I think this is a very good decision for the worker and the average person.
The High Court remitted the matter back to the trustees
to investigate more thoroughly
and to make a further determination. Let's hope the determination was.
You're pretty confident.
Was still with Alan.
Yes.
Alan.
You're pretty confident they'll play it.
You'd think so.
I think so. I think Alan sort of probably got a good result from it all. The trustees would be very mindful that they wouldn't, they wouldn't be subject to further scrutiny by the courts.
But it highlights that you should seek the opinion of a lawyer when you're dealing with these sorts of matters because it's very complicated.
Look, particularly, I think my experience, of probably maybe your experience, Tony, is that when people apply and they're rejected, a lot of people throw up their hands and say, I can't do anything.
Hard. That's right.
So I think a lot of people, when they're rejected, say, oh, look, it's too hard.
No, that's...
And it is important because it's the construction of a deed, and in this case, the High Court specifically said that the trustees could not bring into the deed extra terminology, which was working with the same employer. They imported those words into the definition.
But look, the other thing which strikes me is that people often have checkered work histories and they have an injury, they try and get back to work and they work part-time or under duress. And often, to me, they qualify for under the
disability
definition,
benefit,
but
yes.
a lot of people say no, they don't.
Yeah.
So there's divided opinion.
Yeah, that's right. That's right.
Dare I say, we're optimistic, Tony.
We are. We are.
Is that right? The
Well,
glass
I think
is the glass half full, Tony?
I think it's
Oh,
yeah,
no,
at least
well,
half full.
Is the glass half full?
I think
We're
the High Court
optimistic.
see it the same way too.
Yeah, yeah. So we think that if you've got a superannuation dispute, see a lawyer
You should get advice.
and get advice. And increasingly, I think the quantum's usually over $100,000.
Well, it's getting bigger now because these funds have got money. There's
worth
a lot
your
of money
while.
in the superannuation
It's
business.
worthwhile, yeah. Now, the next case we've got is a case decided in the Magistrates Court about by a well-known magistrate who's got experience in work cover, someone who was injured, and the employer, I think the claims agent, terminates his weekly payments on the basis he can do some work.
Yes, it's a matter of Irwin versus Tabro Meats. Judge Garnett in the Magistrates Court of Victoria, he decides on the issue of weekly payments. Harry correctly states that weekly payments was terminated because the agent says that he can go back to work, even though
Light work or alternate duties.
light work.
He couldn't go back as a meat employee.
No.
So, but they said, look, you can do something. You're not a total cripple, or you can do something.
Yes.
What was important in this case is the fact that he actually asked for computers and
Computer retraining.
retraining, and they didn't pay for it.
Yeah,
The agent just sat on their hands on this one.
yeah.
And
But what the judge said in effect that there's got to be a realistic prospect of getting work.
Exactly.
So-
Look, he's got
degree
a serious hand injury. He's got psychological injuries. He's dyslexic.
and his age.
His age, Tony. How old is
Yes.
he?
He's 55. I think.
55.
It's pretty.
And the judge made it clear a degree of realism has to be imported in these decisions. We can't just simply say that, yes, this guy here can just find some work. You have to actually take the
It's
worker...
not just a theoretical capacity to work.
Exactly. You have to take the worker as you find them.
Yeah.
It becomes very important
And-
when someone's been on payments for more than 2.5 years, Harry.
I didn't. Yeah. Well,
That's it,
after
yeah.
2.5 years in Victoria, a lot of people are terminated.
Well, you need to have no current work capacity. That's the
a lot
reality
of
of
people
it.
are terminated because they have some current work capacity, according to the claims agent. And then, dare I say, that they probably should talk to a lawyer.
Do you know, the show's moved along 100 miles an hour again, and
Yeah.
we've come to the end of this segment.
Thanks
So-
very much, John. You might be back
Thank you.
for by popular demand once again. We're not quite sure.
Thank
Depends
you,
on
Harry,
the
Tony,
public.
and viewers.
And we'll be back after the break for Kathy's mailbag.
Yeah.
Yeah,
Okay.
stay tuned. Thank you.